Do you know that USCIS has just made major changes to I-130 processing priorities in February 2026? If you have a pending family-based immigration case or you want to bring your loved ones to America, this news could change your life. In the next few minutes, I'll tell you how these changes will affect you and what you must do right now. Don't make any decisions without watching this video, because one small mistake can push your case back by months or maybe even years. Hello everyone, and welcome to US Visa Info, your trusted source for the latest and most accurate immigration news. I'm your host, and today we're going to talk about a very important and urgent topic. USCIS, the United States Citizenship and Immigration Services, has announced significant changes to I-130 petition for alien relative processing priorities in February 2026. These changes could affect millions of families who want to bring their spouses, parents, children, or siblings to the United States. If you also have a pending I-130 petition, or if you're planning to apply in the near future, then this video is very important for you. So, please watch this video till the end, and if you find this information helpful, please like and share so that more people can be aware of this important update. At US Visa Info, we always provide you with accurate and timely information, so don't forget to subscribe to the channel and press the bell icon so that you receive every update first. So let's start and understand what this I-130 priority shift actually is and why USCIS has made this decision. First, it's important to understand what the I-130 form is. Form I-130, Petition for Alien Relative, is a document that United States citizens and lawful permanent residents, meaning green card holders, file to bring their family members to America. This is the first and most important step of family-based immigration. When you file the I-130, you're basically proving to USCIS that you and your foreign relative have a valid family relationship. Only after this petition is approved can your family member apply for a visa or proceed with status adjustment. Now let's talk about priority dates and the visa bulletin system, because understanding this is very important. In the United States, a limited number of family-based immigrant visas are available every year, and these visas are distributed based on different categories and countries. When you file the I-130, you receive a priority date, which is usually your filing date. This priority date tells you what your number is in the queue. Every month, the State Department releases a visa bulletin that tells you which priority dates are current for which category and country. When your priority date becomes current, only then can your family member proceed with the visa. In some categories, such as immediate relatives, meaning spouses, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens, they are always current. But in other categories, such as F2A, meaning spouses and unmarried children under 21 of green card holders, F2B, meaning unmarried sons and daughters over 21 of green card holders, F3, meaning married sons and daughters of U.S. citizens, and F4, meaning brothers and sisters of U.S. citizens. The waiting time can be very long, especially for certain countries that have more applications like Mexico, Philippines, India, and China. Now, let's come to the main point of what changed in February 2026. USCIS has announced that they are shifting their processing priorities to improve service and reduce the backlog. Previously, USCIS generally processed cases on a first-in, first-out basis, meaning whoever filed first was processed first. But now they have decided that they will prioritize certain categories and situations. Under this new priority system, immediate relative petitions, meaning IR categories, will receive the highest priority. This means that cases of spouses, unmarried children under 21, and parents of U.S. citizens will be processed first. This decision was made because visa numbers for immediate relatives are unlimited, and by processing them quickly, families can be reunited faster. The second priority category is aged-out cases and humanitarian situations. If a child turns 21 years old and ages out while the petition is pending, or if there are serious medical emergencies, domestic violence, or other humanitarian concerns, such cases will also be prioritized. The third priority is employment-based cases that are related to family-based, where the employer is cooperating more and the case can be resolved quickly. The fourth priority will be given to cases where RFE, meaning request for evidence, or NOID, meaning notice of intent to deny, has been responded to and the case is ready for decision. And finally, routine cases will be processed where there are no special circumstances. This priority shift means that if your case is not in the immediate relative category, your processing time may become even longer. Specifically, there will be more delays in F2A, F2B, F3, and F4 categories. Historically, these categories already had very long wait times. For example, the F4 category, meaning brothers and sisters of U.S. citizens, already has a wait time of more than 15 to 20 years for some countries. Now, after this priority shift, this wait time may increase even more. The F2A category, which is for spouses and children of green card holders, is also now expected to have more delays. Previously, the wait time for this category was approximately 2 to 3 years, but now it could go up to 4 to 5 years. Similar increases are expected in F2B and F3 categories as well. Now the question arises, what should you do in this situation? The first and most important thing is don't panic. These changes are definitely challenging, but if you make smart decisions and do proper planning, you can navigate your case. If you haven't filed the I-130 yet and you're eligible, file as soon as possible because the priority date is established from your filing date. The sooner you file, the sooner your priority date will be set and your place in the queue will be confirmed. Every day of delay can increase your wait time further. This is especially important for people who are going to apply in preference categories, meaning F2A, F2B, F3, or F4. The second important step is to file your petition absolutely accurately and completely. The cleaner and more error-free your petition is, the fewer chances there will be that USCIS will send you an RFE or NOID. If USCIS sees any deficiency in your documents or any information is unclear, they will request additional evidence from you. This process can take months, and your case will go further back. So, when you're filing the I-130, prepare every document properly. Relationship proof should be strong. If you're petitioning for a spouse, submit wedding photos, joint bank accounts, lease agreements, utility bills in both names, communication records, and other evidence that proves your relationship is genuine. If it's a parent-child relationship, include birth certificates, adoption papers if applicable, and other supporting documents. Financial documents are also important, especially if you're filing or will file Form I-864 Affidavit of Support. Keep your tax returns, W-2 forms, pay stubs, and employment verification letters ready. The third important point is that if your case is already pending and you've received an RFE or NOID, submit its response completely before the deadline. USCIS has clearly stated that cases where RFE has been responded to and the case is decision-ready will receive priority. So, if you submit your response quickly and accurately, your case can come into the priority queue and be processed faster. Don't take any shortcuts in the response. Whatever additional evidence or explanation USCIS has requested, provide it. If needed, take the help of an immigration attorney so that your response is strong and convincing. The fourth step is to consider naturalization if you're a green card holder and eligible. This is a very important point. If you're a permanent resident and it's been 5 years since you received your green card, or if you married a U.S. citizen and it's been 3 years, you can apply for U.S. citizenship. After getting citizenship, if you have a pending petition for your spouse or unmarried children under 21, it will automatically convert to the immediate relative category, which will make processing much faster. Similarly, if you have a petition for your parents and you become a citizen, they will also come into the immediate relative category. So, naturalization can significantly speed up your family's immigration process. The fifth important action is to regularly check your case status and maintain communication with USCIS. Create an online account on the USCIS website and regularly log in to check your case status. If your address changes, immediately inform USCIS by filing Form AR-11. If any notices or requests are missed, your case can be denied. Also, stay in contact with your attorney or representative if you've hired someone. They can guide you on what steps to take when. The sixth step is to explore alternative options if possible. For example, if you're a green card holder and have filed an F2A petition for your spouse, consider whether your spouse is eligible for an employment-based visa. If a U.S. employer can sponsor them for H-1B, L-1, or other work visas, you can try that option in parallel as well. This way, if one path is slow, the other path remains open. Similarly, if you have children who are close to 21 and at risk of aging out, check the Child Status Protection Act provisions. CSPA protects children from aging out in certain situations. Discuss with your attorney whether CSPA applies to your case. The seventh and very crucial step is to maintain updated documentation. As time passes, your circumstances may change. If your marital status changes, children are born, address changes, income changes, or any significant life event happens, maintain proper documentation. When your case finally comes for interview or final processing, all these documents will be needed. If you don't have updated documents, there may be more delays in processing. The eighth step is to seriously consider attorney consultation. Immigration law is very complex, and every case is unique. A qualified and experienced immigration attorney can analyze your specific situation and suggest the best strategy. They can also tell you whether an expedite request is possible in your case or whether other options are available. Many people think attorney fees are expensive, but the time and money wasted from one mistake or missed opportunity can be much more than attorney fees. So, this investment is worth it for you and your family's future. The ninth important point is to regularly monitor the visa bulletin. Every month, the State Department updates the visa bulletin. In this bulletin, you can see how priority dates are moving for your category and country. This will give you an idea of approximately when your priority date might become current. The visa bulletin has two dates, final action dates, and dates for filing. The final action date tells you up to which priority date visas are actually being issued. Dates for filing tells you up to which priority date people can file their applications. Follow both dates closely, and as soon as your date becomes current or near current, start your preparation. The 10th step is to do emotional and financial planning as well. Family separation is very difficult, especially when the wait time is so long. Maintain regular communication with your family members, video calls, messages, and when possible, plan visits. Also, plan financially because the immigration process has fees, attorney costs, medical exams, travel expenses, and other costs. Set your budget accordingly. If you're a financial sponsor, maintain your income and assets at a sufficient level because in Form I-864, you have to meet specific income requirements that are equal to or more than 125% of the federal poverty guidelines. The 11th step is to avoid fraud and scams. When people are desperate or frustrated with delays in their case, they become targets for scammers. If anyone promises you that they can expedite your case through some special connection or by giving money, be immediately alert. There are no shortcuts other than USCIS's authorized processes. Only hire licensed attorneys or accredited representatives. You can verify on the Board of Immigration Appeals website whether an attorney or representative is legitimate or not. Share your personal and financial information only with verified sources. The 12th and very critical step is to document humanitarian circumstances if applicable. If there is a serious medical emergency in your case, a situation of abuse or domestic violence or other exceptional and compelling humanitarian reasons, prepare proper documentation. For medical emergencies, you need detailed letters from doctors that explain the severity of the condition and mention that the beneficiary's presence in the United States is medically necessary. In abuse cases, police reports, protection orders, medical records, and statements from counselors or social workers are helpful for these humanitarian requests. You can submit an I-130 expedite request with supporting evidence. USCIS reviews each expedite request individually, so it's important to present a comprehensive and compelling case. The 13th step is to take timely action for aged-out protection. If your children are approaching the age of 21 and your I-130 petition is taking time to be approved, it's important to take advantage of Child Status Protection Act provisions. Under CSPA, in some situations, the child's age can be frozen or adjusted. But for this, you have to follow a specific timeline and submit proper documentation. Late action can cause this benefit to be missed, and the child can age out and shift to the preference category, which means more years of wait time. The 14th important consideration is to understand country-specific backlogs. Applicants from China, India, Mexico, and the Philippines especially have to face more backlogs because more applications come from these countries. Due to per-country limits, applicants from these countries have to wait more than applicants from other countries. If you're from these countries, have realistic expectations and plan accordingly. Sometimes changing the beneficiary's citizenship or nationality can also help legally if citizenship of another country is eligible and it's possible to acquire, but this is a very complex legal area and professional advice is necessary. The 15th step is to do advanced preparation for the interview. When your priority date finally becomes current and a visa interview or adjustment of status interview is scheduled, you should be completely prepared. In interviews, the consular officer or USCIS officer verifies the genuineness of the relationship, does a background check, and confirms eligibility. Keep all your original documents organized. Relationship proofs, financial documents, police clearance certificates, medical exam results, and whatever required documents there are. Keep everything ready. Practice for interview questions. Common questions are how you met, relationship timeline, family background, future plans, and financial situation. Giving truthful and consistent answers is very important. Providing any false information can lead to serious consequences, including permanent bar on entry to the United States. The 16th consideration is to follow pending legislation and policy changes. Immigration laws and policies sometimes keep changing. New administrations, court decisions, or congressional legislation can bring changes in processing priorities, backlogs, or eligibility requirements. Regularly follow reliable sources like US Visa Info so that you stay updated. Sometimes positive changes also come that can benefit your case, such as special provisions to reduce backlogs or initiatives to improve processing time. The 17th point is to consider alternative family members filing petitions. If multiple family members are U.S. citizens or green card holders and are eligible to file petitions, they can all file. For example, if a beneficiary's brother, who is a U.S. citizen, has filed a petition in the F4 category, and later his sister also becomes a U.S. citizen, she can also file a new petition. This way, multiple petitions can be pending, and the beneficiary can proceed through whichever becomes current first. Many families use this strategy to have multiple chances. The 18th step is that the beneficiary should also remain active in their country. The beneficiary should also do preparation from their side. Educational credentials, employment records, police clearance certificates, medical records, and other documents should be kept organized. They can also gather information about the U.S., improve English language skills if necessary, and generally remain productive in life. All these factors create a positive impression in the interview and strengthen the case. The 19th important factor is to have patience and persistence. The most difficult thing in family-based immigration is the long wait time. Being away from your loved ones for years is emotionally and practically challenging. But if you followed the right process and done everything properly, eventually your case will be processed and your family will unite. During that time, maintaining a positive attitude, keeping hope, and moving step by step towards your goals is important. Many families have gone through this journey and have successfully reunited. Your case will also be successful if you keep putting in consistent effort and follow proper guidance. The 20th and last actionable step is to seek community support. You're not alone in the immigration journey. There are many support groups, online communities, local organizations that help immigrants and their families. Joining these communities gives you emotional support. Information is shared, and sometimes you also get valuable advice from other people's experiences. Churches, mosques, community centers, and immigrant advocacy organizations also provide resources. Use these resources and build a network. So friends, these were the main points you should understand about USCIS's February 2026 I-130 priority shift. and these were the steps you should take to handle your case in the best possible way. I know this news is frustrating, especially for those people whose cases are already pending in preference categories. But remember that with proper planning, accurate documentation, and timely action, you can improve your situation. Every case is unique, so make decisions according to your specific circumstances and take professional help when needed. So friends, this was today's important information about USCIS's latest I-130 priority shift. I hope this video was helpful for you and you got a clear picture of what you should do. If you have any questions or want to discuss your specific situation, definitely write in the comment section. I and our US Visa Info team read your comments and try to provide helpful information as much as possible. But remember that information given in comments is general guidance and not legal advice. For your specific case, always consult with a qualified immigration attorney. If you found this video helpful, please press the like button and share with your friends and family members who are also going through the immigration process. By sharing, you can help others too. And if you haven't subscribed to the US Visa Info channel yet, subscribe now and press the bell icon so that you get notification of every new video. We regularly bring United States immigration and visa-related updates that can be very important for you. Friends, the immigration journey can be long and challenging, but with the right information and proper guidance, you can achieve your goals. US Visa Info is always with you in this journey. May God give you all success, and may your families unite as soon as possible. Take care, and see you in the next video with another important update. Stay informed and stay blessed.